Hello and welcome to the first session of Series 3 of Prime Time, Prime Finance's virtual events programme. Before we get started, I'd like you all to know that this session is being recorded and will be distributed on various channels later. Attendees are muted and have their videos switched off. If you have a question or comment, we'd love to hear from you. Please do get in touch using the Q&A function. It can be helpful to include your name and affiliation. We'll be using the chat box to send messages to all attendees during the course of this session. I'd like to thank Dwarf Financial Technologies and FTI Consulting for sponsoring this series of Prime Time. Thank you also to Lexis for supporting Prime Time and assisting with promotion. I'm now going to pass over to Jeff Golden to begin these proceedings.
Thank you, Camilla. Ladies and gentlemen, friends of Prime Finance, good morning, good afternoon, or good evening, depending upon where you are. My name is Jeff Golden, and I'm a member of Prime Finance's advisory board. And I had the honor and privilege of chairing the Prime Finance Foundation in its formation period. Well, the honor of association with the project and certain privileges for me continue. And the privilege that I have today is to welcome you to this, the first in our Legends series. The panel of experts from around the world who make up Prime Finance's offering now numbers more than 200 experts, and together they represent collectively more than 6,500 years of relevant experience. It's an interdisciplinary panel combining expertise in finance and dispute settlement. And today we feature two of our panel members, two legends in the law, the Honorable Charles N. Brower and Baron Thomas of Cwmgiedd. They need no introduction, but let me highlight from their incredible careers a couple of facts just by way of reminder. Judge Brower currently serves, as he has done since 2014, as a judge ad hoc at the International Court of Justice, where he had previously represented various governments in proceedings before the ICJ. He has served continuously since 1983 as a judge of the Iran-United States Claims Tribunal in The Hague, although that service was interrupted for some months in 1987 by White House service as Deputy Special Counselor to President Reagan, having earlier in his career served as acting legal advisor at the U.S. State Department. And in his 60-year career in the law, Judge Brower has earned several Lifetime Achievement Awards for his role as counsel or arbitrator in arbitration cases on all 6 continents and under all the major arbitral rule regimes. A career that has combined extensive practice at the bar with distinguished public service, both national and international. The publication, The American Lawyer, has described him as, and I'm quoting, the reigning king of international arbitrators. For many years, partner at White & Case, co-founder of the White & Case Washington, D.C. office, Judge Brower now conducts his arbitration practice at 20 Essex Chambers. Lord Thomas is a former commercial court judge where he became the judge in charge of that court. He subsequently became a Lord Justice of Appeal and held appointments as Senior Presiding Judge of England and Wales, Vice President and later President of the Queen's Bench Division, and Lord Chief Justice of England and Wales from 2013 until October 2017. He currently is the chairman of the London Financial Markets Law Committee, president of the Qatar International Court Committee, an arbitrator at Essex Court Chambers, first vice president of the European Law Institute in Vienna, chancellor of Aberystwyth University, and of course, he participates in the business of the House of Lords. His public duties have involved Lord Thomas in a number of high-profile matters, including the inquiry into the affairs of Robert Maxwell, and more recently, he was one of the 3 judges, the most senior member, forming the divisional court that heard the Gina Miller judicial review of the use of the royal prerogative in the run-up to Brexit. Most importantly, to my mind, Lord Thomas was a driving force in the creation of the financial lists established by the High Court and first announced in his 2015 Mansion House dinner speech to Her Majesty's judges. And we'll come back to the subject of the financial list. Well, now I'm excited, and I think you should be too, as we have this opportunity to listen to how our speakers' experiences over the years help shape their thinking about dispute settlement in the financial markets. And we have a number of listeners at the early stage of their legal career. So let's begin at the beginning. I'd like us to kick off with the early experiences and influences that the two of you off on your career paths. Judge Bauer, let me start with you. We share New Jersey as our home state, or New Jersey as some of the tough guys where I grew up used to call it. We both identify strongly with growing up there, though I suspect for both of us at times it seemed a long way away. Please tell us about your path from New Jersey and the influences on the early decisions that you made about your career choices.
Thank you very much. I want to note that South River was on the football schedule from time to time in my hometown, Westfield, New Jersey. And you're right, it was a bunch of tough guys. I'll leave it at that. People are amazed when I say when I was graduating from high school, our guidance counselor asked everybody in private, well, what are your goals? What do you want to do? And I answered, I will become either a pediatrician or a forest ranger. These were the products of my very early years. But by the time I graduated from Harvard College, I was set on joining the United States Foreign Service. And I had passed all the exams and I had my number. I could join whenever the next vacancy would arise. I had a Fulbright scholarship for a year in Germany, in Bonn, and in Berlin, and my eligibility was held open for that. But in the meantime, I had been convinced by my two mentors of the time to go to law school, even though I was going into the Foreign Service. You have to remember, this is Joseph McCarthy times in the early 50s, and a lot of bad things that happened to really good people in the Foreign Service as a result. And my tutor in the English university sense in the honors program at Harvard was wanting to go into the Foreign Service. And he said anybody who's doing that should get either a PhD or a law degree. So if bad things happen to you, you have an alternative. So I always said I never went to law school to become a lawyer. And who would ever want to become a judge? I just had no interest in that. I was going into the Foreign Service, and it would be an advantage. And since the accidental time of my birth basically left me out of the Vietnam War draft, I was, I had time. So that was where I was going. But then, since I was 26 when I graduated from law school, and I say I had no military service, I said, and I had the opportunity to join White in the case in New York. I said, I'd be an idiot not to punch this ticket for 2 years before I go into the Foreign Service, and I have some practice experience. Well, they say the best laid plans of mice and men of Cwmgiedd, and that was the case. I was quickly captured by the law. I had found my métier. I love to go to court and intellectual combat in real time, and that got me started. The international law bit came later. Obviously, I was following a elected political career alongside of trying to become, which I did, a partner of White and Case. So when Nixon was elected, I managed to go off to Washington to the State Department for 4 years, which in a sense was the real beginning of the rest of my life. Oh, that's don't think you know what you want to be necessarily, although some people do. Life takes you strange ways.
It does indeed. Lord Thomas, you've also felt a great sense of loyalty to your Welsh roots, and I believe you're speaking to us from Wales today. You currently serve as Chancellor of Aberystwyth University, recently chaired for the Government of Wales a commission on the operation of justice in Wales, but much of your education took you further afield. Rugby Cambridge University, and the University of Chicago Law School. I've teased you about bringing back more than a JD law degree from the US since I think you met Lady Thomas while you were at Chicago. But were there, there milestones or key influences that stand out along with your becoming head of the judiciary, president of the courts, the most senior judge in the UK, that might be of interest to our audience?
I come from a time when it was difficult to persuade people to read law. And so I went on a course when I was 16 where people tried to persuade you to come to university to do it. And I think I didn't have the interesting career of Judge Breyer. In doing lots of other things, I became almost wedded to the law when I was 16. Since that time, I've been really very lucky indeed. I think my first piece of work was to go to a set of chambers where there was not a lot of work, but people who were wonderful to listen to. And there were people like Sir Michael Carr, Lord Mustill, Lord Stone, Lord Savile. And then the bar was small. We all used to go and have coffee in the mornings because there was no work to do. And so you sat and listened to people like Robert Goff, and Nicholas Phillips and others drinking coffee. And that was a really excellent education. But life slightly became more serious with the various crises in the markets. And I think I would agree with Judge Breyer that actually it's the luck of what happens in the markets that influences your career. And what influenced mine very substantially were the terrible problems at Lloyd's, brought about partly as a result of the growth of the market, partly as a result of the asbestosis problems, and some would attribute it to the ingenuity of American lawyers of producing huge amounts of litigation. And that was very, very interesting. And it led me at the end to decide we had to do something about reinsurance. The market was such a problem. And I had a sort of hand in setting up a reinsurance organization, which is flourishing, in the 1990s, and it's flourishing still today. I then sort of had a slight change and did one bit of public service, which was to inquire into the affairs of the late Captain Robert Maxwell, MC, shortly before he died. And that was fascinating because one saw how a man like that is really propped up by people being prepared to lend their name to him. When Trollope wrote about dukes on boards, not much has changed. You always, if you're a crook, look to the veneer of respectability around you. And then I was quite lucky and I got involved in various European things and helped set up the European Network for the Councils of the Judiciary and more recently the European Law Institute. And when I became a judge, I spent quite a lot of the time really fighting for the establishment of a more independent judiciary in the UK and fighting to maintain it thereafter, including being called an enemy of the people, as Jeff has, in the case Jeff has referred to.
Yes. Yes, I think the rule of law was lost on the newspapers for a short time on that occasion. Actually, let's talk a little bit about civility. Judge Brower, let me return to one of your professional experiences I happen to know about. Civility is a topic much talked about at the moment in the context of the dispute settlement, at least in the United States. These are interesting times in politics and in the courts. Prime Finance board member and as of 2 weeks ago, nominee president-elect of the American Bar Association, our friend Deborah Enix Ross, has said that she will put civility at the top of her agenda during her term as ABA president. Well, exchanges between counsel can be heated. Some judges, some arbitrators are more aggressive than others in confronting or questioning counsel. But Judge Power, you actually saw 2 judges of an international tribunal come to blows. Can you tell us about that?
I think the only instance in history, at least, which has been public, when 2 judges attacked a 3rd judge. We were 9 altogether: 3 Iranians, 3 Americans, and 3 from other countries. And on the 4th of September, 1984, when I had been there just a few months, more or less, we were coming down the stairs from the 2nd floor, American 2nd floor, where all the offices were to meet in the meeting room, all 9 of us, for an administrative meeting. And as Judge Mungard, who was the Court of Appeals judge from Sweden before, and was the chairman of the Chamber of Three, in which I was sitting at the time, came down the stairs. Two of the Iranian judges assaulted him. You have to remember that at the beginning we had true revolutionaries, for the most part, being appointed by Iran. It was early days, and they grabbed him. They grabbed him partly by the tie, swung him around, put their arms around. Basically, they were trying to throw him out of the building. And that was because our chamber was working faster than others and causing more damage to Iran on behalf of American claimants. I was just coming down the stairs as that was beginning. I immediately called David Caron, my law clerk, who was a big guy and a Coast Guard officer for 5 years, said, come on down right away. Already the United States agent and the deputy agent, and actually the third Iranian judge who was in my chamber, were helping break this up. I went straight to the guards room and said, call the police. Police came. But the other Swede, Gunnar Lagergren, who felt himself several classes above a mere Court of Appeals judge from Sweden, refused to allow the police to enter. So basically, we all told Judge Mangard, go home, okay, and go to his home in The Hague, and we get this straightened out. Interestingly, the Americans asked the president to bar the two judges who had made the attack from the building, and he refused. So for days, these guys were allowed to roam around the place. Of course, Niels Mangard stayed at his home. Well, it could be a very long story, but I will try and summarize it. Basically, Gunnar Lagergren tried to broker a deal whereby there would be, he would meet in the Peace Palace, which was not where our court was sitting at the time, with not the lead man, Judge Kashani. Judge Kashani, by the way, was the son of, his father was the Grand Ayatollah at the time of Mossadegh, elected head of Iran, who had been overthrown and the Shah returned by Kermit Roosevelt and some other Central Intelligence Agency people with some British assistance, as I recall. And Kashani, the son, the judge himself, later ran for president of Iran and was a distant third, I'm glad to say. But his motivation was he was against this whole tribunal business. He wanted to destroy it. And he kept saying this back to Tehran. And the week before this assault, he had been visited by agents from Iran telling him to shut up and stop it. And he didn't agree with that. And he felt that if he caused a real ruckus at the tribunal, his government would stand behind him. Well, in the interesting Iranian way, Iran never, in any words, accepted the challenge which the United States obviously made to both of these judges. But after some weeks, we received from the agent simply a note that on such and such a date in December, 2 new judges would arrive from Iran, which the majority of the tribunal interpreted as an acceptance, and off they went. In the meantime, Judge Mangard refused, on strongly advised by the Americans, to accept the solution that Judge Gunnar Lagergren had been Marshal of the Realm. He married a Wallenberg, which is big money in The Hague, and he was the second ranking in protocol as Master Marshal following the sovereign. And his deal was, we'll meet in the, I'll preside over a meeting in The Hague between the, not Kashani, but the second guy, Shafi'i, who participated in this. And he will shake hands and make peace, and you, Mangard, will resign 30 days later. And we said, that's a terrible idea. And we were able to convince Mangard without too much trouble, hang in there. And if the United States challenge should succeed, well, it was never decided because the Iranians gave up. But if it should succeed, you can come back in honor. If it doesn't succeed, nobody is going to blame you for resigning in the face of such a horrible decision not to throw out those two Iranians. So yeah, lots of politics, very interesting. But I must say, leaving aside current politics in my home country and yours, yes, civility is extremely important, and one has to sometimes one has to learn how to enforce it in an arbitral proceeding, or indeed sometimes in American courts.
Gosh, Lord Thomas, I'm guessing you would say that high standards of civility have long prevailed in the courts in which you have served. I mean, what would you point to that might account for that?
That there is. Oh, I'm sorry.
No, the Lord Thomas.
You're addressing Lord Thomas.
Just get a comparative view on all that.
Yes, right. I'm afraid that he's got the upper hand on that.
Well, I think it's fortune in one sense, in that our bar was relatively and has remained relatively small, and when people know each other well, they tend to behave in a civilized manner to each other, and that is to an extent encouraged by by our system of Inns of Court. And it was interesting that Lee Kuan Yew, who decided that the way to try and make the Singapore bar behave in a politer manner was to ensure that you had Inns of Court. So I think they do make a difference. And I'm very glad the American Inns of Court, and I went to Washington to talk about this subject, are doing so much to promote civility. But I also think, and here I agree entirely with Judge Ryan, that the judges a really firm hand in anyone who's rude or difficult. I remember on one occasion when I was quite young, two lawyers started to quarrel. The judge looked at them both and said, "When you two have learned to behave, I'll come back," and got up and walked out. And it stunned them into silence. And there was not a peak of the whole atmosphere changed. And I think you sometimes have to be quite tough in doing something of that kind.
Well, actually, I'm glad for that shout out to the American Inns of Court, because we actually have people from the American Inns of Court who are listening into this program, and I know that's part of their reason for being, is to promote those same values on that side of the pond. Gentlemen, let's move the conversation, if we can, to courts versus arbitration, or courts in comparison with arbitration. It's noteworthy that you both are successful arbitrators, but that you both draw on considerable courtroom experience as well. And our audience, I think, will be interested on your views of the comparative merits of arbitration and courtroom litigation, particularly as we contemplate disputes arising in the financial markets. Now, I should quickly add, at P.R.I.M.E, we don't view this as a competition. We view our arbitration offering as a complement to the role that courts can play in fostering financial market stability. And in fact, a big part, probably the bigger part of our activity to date, has been in connection with court cases, providing experts for cases being heard in national courts like the Lehman cases, providing technical assistance and training to domestic court judges around the world about derivatives and other matters of finance. But Judge Bauer, let me start with you. We've seen this marked increase in interest, particularly in certain parts of the world, including parts of Asia and in the emerging markets, in the use of arbitration and ADR in connection with financial market disputes. And based on your experience, what are the positives about arbitration that might account for this?
Well, I think, as the saying goes, there are horses for courses, or courses for horses. It depends upon the situation. Obviously, arbitration has the advantage, so far anyhow, of being a system whereby, in general, each side of the case appoints an arbitrator, that arbitrator is to be wholly independent, impartial, so forth, but might have a particular expertise needed in the case, or a particular cultural understanding of the background. And then the third person is chosen by one process or another to preside over it. And of course, this is very important in international matters, because neither party wants to be in the municipal courts of the other party. They're just want to stay away from it, generally speaking. On the other hand, a court is a state entity, and you're sitting before a judge, generally speaking, or in appeals maybe before more. So you don't have the concern that you would about, well, what is this arbitrator appointed by the other party, really going to be doing, or going to be living up to their mandate. You will find there's a lot of cultural aspects of this too, because clearly in the Orient, the element of saving face is important. There is a pronounced lack vis-a-vis the West of an appetite for confrontation, but hopefully for peaceful settlement of things. And it happens even in the West. I have to say, I've had the experience with Swiss arbitrators who, generally speaking, always feel it's part of their job to encourage settlement and bring it up. And I think I've had with Swedish arbitrators in particular also, well, can't this be settled somehow? And not a great appetite for, as I say, confrontation. So it depends upon the case and sometimes the cultural background, but it certainly is growing. I also have the ADR of all kinds, and I'm having currently the experience of ADR in some form being promoted by people in countries where the courts are regarded as likely being corrupt. It gives a private way of people getting their disputes done without being subjected to what they regard as politically influenced and otherwise corrupt courts.
Well, I guess there's a balance to be maintained. At one level, Lord Thomas, when we think about arbitration and the courts, it is probably about getting a certain balance right. You've worried about balancing the parties' near-term interest in getting their disputes settled quickly, authoritatively, cost-effectively, certainty being a primary interest of the financial markets. And Judge Brower brings up even the specter of corruption and the like. But balancing that with a wider market or even public interest in ensuring, and here I'm quoting from something you wrote, that there is in place the right dispute resolution methods to develop the law that underpins markets, trades, and commerce.
Mm-hmm.
Would you?
Yeah, I think what I would say is that the most important thing is to have a tribunal that you can trust. And over the centuries, I think the kind of person who wants dispute settled, particularly in markets, has always looked to try and find what will serve them best. And if one looks at what's happened in England and Wales over the last 2 centuries, we've fluctuated between the two. I take the view that a market generally wants to know what the law will be for the future. And it can be done by arbitration if you get rid of the illusion of confidentiality. I remember when the arbitration bill came up here, someone got up who was a very experienced market practitioner and said they thought confidentiality was nonsense, because you could always find out in a market what the result of a dispute was, because everyone gossiped about it. And I think I take a great interest in what the Court of Arbitration of Sport has done, or what the American maritime arbitrators have done for very much longer, and that's developed their own system for publishing decisions. But what the parties really want is an expert tribunal. And in the courts have got a lot better. When the courts have produced people who are no good, people have gone from them. And now I've been quite active in trying to promote across the world the development of much better commercial courts. London's always been fortunate. Singapore is now very fortunate in having a first-rate commercial court. And I think that where you have international courts that deal with commercial disputes in an even-handed way with expertise, I think they work very, very well indeed. But I'm equally confident, providing you can get rid of this nonsense of confidentiality in market disputes, that actually an arbitration of the right tribunal. Certainly, my experience was when the reinsurance market went into terrible trouble, that you actually needed a tribunal that was chaired by experienced people. But whichever way you do it, you need decisions for the future by people you can trust who are absolutely honest.
Well, let's go there next, because that is an overarching question at the moment in dispute settlement of generalist judges and arbitrators versus a more specialist approach. Lord Thomas, tell us a bit more about the financial list. We've had special subject matter courts or tribunals where context was thought important to deal with everything from family law to juvenile crime to tax to employment to immigration for a long time. But until the financial list, which you championed in the UK, we didn't have that specifically for finance. Is finance different? And if so, why? And if not, why not?
I think each market has enough detail and enough of the way in which it works that a judge must, when he starts, at least understand how it works. I remember when there were very few reinsurance cases in the commercial courts in London, my clients who were members of the Lloyd's market were utterly horrified when the judge asked a question which showed he knew nothing about the market. And I think that if you, and you're told as a judge, if you're doing, for example, some very complicated science case, ask the questions very discreetly, because nothing upsets people more if they see someone who is sitting there who really doesn't understand what the case is actually about. And therefore, we took the view that in the financial markets, the evolution of new forms of instrument, the new evolution of ways of doing things were constantly evolving at a pace that probably has increased, as it has in other markets, in a much greater degree. And therefore, if judges were to command the confidence of the financial markets and understand if they made a decision that was awful in terms of what it did to the markets would never come back to the courts. But at least have judges who understood the markets, and at least if they made a decision that the market didn't like, they would make it with sufficient understanding. And therefore, I've been immensely grateful to you and others in actually helping get the judges up to date. And these days, because the markets change so fast, you need to do this almost on an annual basis.
I think that's right. Well, this whole issue of staying abreast of market developments and how do we ensure that judges and arbitrators who have relevant experience, are equipped, as you say, to understand changing markets. And those training programs are important. Let me ask Judge Barrow. Let me ask you, because on the question of who makes the best international judge or arbitrator in complex cases, you've sat on international tribunals of general jurisdiction like the ICJ, specialist international tribunals like the U.S.-Iran Claims Tribunal you were talking about earlier. In your experience, can you generalize? Is it easier to teach a judge complex finance or international law, or financial markets or international law expert how to judge?
Well, how to judge is, I guess, an art in a way. But the issue really is exactly how to prepare people who will judge for what they are going to judge. Now, it's interesting we're talking about finance, but I can tell you the American Society of International Law has had a program recently revived, which had been chaired by Ruth Bader Ginsburg, um, and um, and before that by Sandra Day O'Connor from the United States Supreme Court, to educate judges, particularly federal judges in the United States, about international law because it comes up in their cases. And I remember being in the Ninth Circuit Judicial Conference some years ago, which was Sandra Day O'Connor, when she was still on the court. She was a circuit judge on the Supreme. I mean, she was in charge of that circuit on the Supreme Court. And we had quite a session. She had actually called every chief judge of every United States Court of Appeals in the United States and said, you will have on your next judicial conference a program on international law, but you tell us what's most important. And in some circuits, it would be more immigration and naturalization issues, asylum issues, which are international in a sense, and others would have sovereign immunity, more sovereign immunity cases. But it requires constant education of the judges. Now, I think always the best judge. I've never been a judge in the United States. I sometimes say I've never been a real judge in some people's eyes, but I think the best judge is the one with the most experience, broadest experience of many fields, and they can learn, but they need to be taught from time to time. And there's a natural, how should I say, gravitational pull in different directions. Maritime arbitration. You have maritime arbitrators who do nothing but maritime arbitrations. It's been a specialty for a very long time. Specialties do develop. They're treasured. And in some areas, things don't change that much. In others, they change terrifically. And I, as someone who litigated for over a period of 30 years as a partner of White and Case in domestic courts, in everything from defending exploding beer bottle cases for Budweiser in New York City and libel cases for McGraw-Hill, and then moving to Washington and reveling in having no discovery proceedings, just suing the federal government to enjoin them from doing stupid things, to what I've been now. Take me as an example. I'm sitting in 3 cases as Judge Hoke on the International Court of Justice, now 2 by appointment of the United States in cases which Iran has brought against the United States. And so I know that territory very well. But my first appointment was by Colombia, defending against Nicaragua. The case is, get this, what is the maritime boundary on the continental shelf beyond 200 nautical miles from the line from which the territorial sea is measured? You think I'm an expert on on that subject? Well, I do know something about it, thanks to the years I spent in the State Department. But I'm going to have to do a lot of I'm going to have to do a lot of learning in order to fulfill the function. So, I mean, life is a constant education. It needs to be for judges, and there need to be efforts like P.R.I.M.E. Is very tellingly making, to be sure that judges who will sit in these matters know what they're talking about and don't don't disgrace themselves before the litigants in the fashion that Lord Thomas has mentioned.
Well, I'm glad you mentioned maritime law, because that is an area of law where lay expertise as well as legal expertise have worked together to get results that would work for the markets. How do you ensure not just relevant and current specialist knowledge, but also judges and arbitrators who can be expected to be pragmatic in finding a solution that's principled, but one that suits the markets? How do we best do that? Lord Thomas, you've cited in your speeches and writings, Lord Mansfield's 18th century example of dining with leading merchants and traders to ensure that he kept up to date with the latest developments in the markets. And I guess the common law also lends itself to building principles in that sort of way. Although we have a tension when we look out there between the flexibility of a common law approach and a civil code expectation that a code will be best in providing right answers. But what do the two of you think, Lord Thomas? Did Lord Mansfield get it right in terms of his reliance on those dinners and the role of experts and market assessors in the cases he heard?
By and large, yes. One obviously couldn't these days do it that way. You have to do it in a much more structured and open way. If you went and had dinner with a whole lot of people down in the city or amongst another group of merchants, people would think that you were just sort of getting the establishment line or getting something even more sinister. And so I do think but you do need to be kept up to date. And what a judge can do, and I think this is in a way where there is an advantage in balancing the approach of the court and the approach of arbitrators, is to follow what Lord Mansfield did, which although you have issues that you decide in each case, you do need to stand back from time to time and try and systematize it. And that was Lord Mansfield's great achievement. You can rely on a code, and it's one of the concerns I have at present. Particularly in relation to technology, the technology is going so quickly that I do sometimes worry as to whether codes can keep up to date. I mean, one of the great achievements the European Union thinks it is the GDPR. But many people wonder now, actually, hasn't that frozen things at a state of technology that isn't that old? And so I do think there is something to be said for the approach of finding out how decisions should be made that suit the way to develop international business, and then stand back and systematize it, because you have a flexibility that a code can never really match. It'll be interesting to see what happens over the next 10 years as our law undergoes profound change to deal with the technology. I think it's a very interesting challenge, but we need to work very closely together to do this.
Judge Brower, anything you would add to that? I mean, the tension you've seen working in international tribunals between the approach of civil code trained lawyers and common law lawyers?
Oh, well, I would say very much so. I think the civil law system, basically by taking people who've had some years of practice and then making them judges, or dealing with people who've had to learn all different kinds of things according to their clients' needs along the way. You have a very broad practice, whereas civil system judges you study to be a judge. I mean, that's what you do. And you're going to be a judge for the rest of your life, basically, without ever having a significant actual practical experience at the bar arguing cases, and certainly not over a long period of time. If you've been in practice, unless you wind up in a very narrow scope of practice, your whole life has been learning other people's business all along. You're trained to soak it up, and I think that gives common law lawyers a tremendous advantage, both in arbitration and in judicial proceedings.
Well, I'm conscious of time, and I'd like to give attention to comments that we've had from our audience, and one of them has reminded me that we should give a shout out to International Women's Day. Because of scheduling, we do not have one of the many women who are P.R.I.M.E experts with us today, but we will have a woman who is a true legend in the market, Skay Evans, a former chair of ISDA, former head of markets and exchanges at the FCA and currently chair of the LMA, joining for our next session. And I hope this audience will join for that one as well. But Judge Elizabeth Stong has asked that in light of International Women's Day, perhaps as you were reflecting earlier on your careers, you might reflect on whether there were any particular women that were an influence or whose experience you very much appreciated. It's funny, we've been talking about the International Court of Justice, and the first woman judge on that court, who went on to be the president of that court, was
Rosalind Higgins.
Rosalind Higgins. I was in her first class ever that she taught at London School of Economics. and she has been a mentor to me personally ever since. So that's just one example of many that I could cite. But Lord Thomas,
well, can I say this? I think one of the problems has been that I certainly saw in my career the way in which the judicial establishment and quite a lot of the professional establishment was very anti-women. And it's one of the things I've always tried to do is to try and redress this balance. It horrifies me still that despite the fact that that for the last 40 years, there have been as many, if not more, women at university than men, that we still do not have a proper balance at the top of the profession. I think part of this is career opportunity. Part of it in the past is due to outright prejudice. And I think a failure to take into account that actually, if you're to get the best, you need to be very flexible in the way you organize and promote people and deal with people's careers. But that's why I've always, felt that there's a great deal more to be done. And it needs doing now, not in 50 years' time, as one former Supreme Court judge said. His views, quite frankly, were shocking in that respect. Of women that I know, obviously, Ros Higgins was a member of my chambers, and I was greatly admired her. But I've been very much influenced, I think, by Brenda Hale, who is absolutely wonderful. She's a very powerful judge. I remember going on circuit with her and seeing her steal. That's a very long time ago now, about a quarter of a century ago. And then I think the one of the really outstanding women was Dame Elizabeth Butler-Sloss, Baroness Butler-Sloss, who came up from being a registrar, so low rank of judge, right to the top, and has always been and still is a very, very powerful figure. But we need many more of those, and I wish the judiciary could move much more quickly at its senior ranks to having a much stronger balance than currently exists. And it shouldn't take 50 years.
Well, I think in the last couple of days, did I see an announcement that Lady Justice Rose is going to the...
Yep, that's an excellent
and isn't she a former financial list judge as well, as I recall? She
Yes.
certainly in the audience when I spoke to the judges on the list. So that's a great news, and of course, Lady Arden is who gave the keynote at our last in-person annual meeting at Prime Finance, has handled some of the most important ISDA cases as well. So we had a way to go, but I think we're seeing some very encouraging steps in the right direction. And thank you, Elizabeth, for drawing attention to the date.
May I just add that we now have the second woman president of the International Court of Justice, President Joan Donoghue from the United States of America. And on just a personal note, the longer I was practicing at White and Case, and certainly in the later years, I realized the associates and colleagues working on cases with me were almost exclusively women. And it was not a campaign. It was not a design. I just picked the best people available to work on my cases. So there is hope. and there is a lot to be done.
President Donahue also joined us for one of our recent Prime annual events and has a considerable financial law background herself
Mhm.
from Washington. That's exciting news. When I
She
saw
was
that.
I believe she was at the Treasury Department in one of her appointments.
That's right, but I think she was with the one of the agencies before that as well. Uh, can't remember off the top of my head.
Well, she also happened to be principal deputy legal advisor and then a long time acting legal advisor of the Department of State. So that's not a bad place to come from, I'm told.
Well, again, I'm conscious of time, and to conclude, I'd really like to get the thoughts of the both of you as to what you see as the potential for that prime finance talent pool that I was bragging about right at the outset. What uses we can put that to make a positive difference, and how might prime finance best organize itself to realize the potential that that group represents?
Well, it seems to me you're doing the right things, which is educating lawyers in what they need to know to deal knowledgeably or seeming to deal knowledgeably at a minimum, and hopefully really knowledgeably on complicated financial matters. And the other, of course, is teeing up experts who are called upon by litigating parties, or perhaps by courts as well, or arbitral tribunals, as experts to provide what is necessary. I think those are really extremely important. Beyond that, well, we take one step at a time. I think those are really important missions that Prime is on.
Thank you, Lord Thomas. I think you get the last word on this.
Well, it's not the last word, because there are many more wise people who are much wiser than me in this area. But what I would say is that I entirely agree with Judge Breyer. Training the judges is critical, and I'm terribly grateful for all Prime has done and will continue to do in that respect, both here and overseas, because we must remember it is very, very important we bring all commercial courts across the world, and the organization which we putting these together, called the Standing International Forum of Commercial Courts, is doing this. That's the first thing. The second thing is having experts who can come and give evidence. And the most important thing about an expert who gives evidence is that they give the evidence as a person of complete integrity. They are not advocates. It becomes immediately obvious once an expert becomes an advocate, and the credibility falls straight to almost zero. I think that is a very, very important function of Prime. But I do also feel that in the end of the day, there are cases where a proper market arbitration system really is first rate, partly in providing mediation. Secondly, in dealing with disputes sometimes that are extraordinarily expensive to deal with in court, and that's the assessment of damages. People in the market have a much greater feel for what someone's actually lost than a judge ever will. And thirdly, I do think if you can get to a point where you can systematize decision-making in the way the New York Maritime American arbitrators and maritime arbitrators have done, or for example, the Court for the Arbitration of Sport, these can provide for a market a level of decision making that is accepted. It in the end needs systematization, and that's why the interrelationship between the arbitration and the courts is so important. But I see a huge future for Prime in these three areas, and my last word is to say that not only the financial markets, but actually the whole of international trade should be terribly grateful to an organization like P.R.I.M.E in making certain that the quality of decision making, whether it be through help to a court, through training, or through expert evidence, or by its own devices, is as high as possible. Because if we don't have the rule of law, systematized, proper, fair decisions, then international finance in the end is the real loser, and thereby we are all losers.
Well, I'm going to exercise the prerogative of the moderator to have a last word, and it's really to thank the two of you for sharing these thoughts and your time with us in this way. I'm afraid it's all we otherwise have time for, but you see this Cheshire Cat grin that I'm wearing. Somebody very clever once said, "You're only as good as the company you keep," and I'm feeling very good indeed at the moment, having kept the company, the inspiring company of two legal legends this past hour. And so it remains, again, just to thank our two speakers for their contributions. Thank you, our attendees, for joining us, and return the floor to our head of secretariat, Camilla McPherson, to close the proceedings. Right on the button. Camilla?
Thank you so much, Jeff. Well, to find out about upcoming sessions of Prime Time, please do take a look at our website. Our next two sessions are open for registration now. That's Brexit and the impact on financial services, as Jeff mentioned, featuring Gay Evans, amongst others. And then at the end of March, our session on sustainable finance, featuring Dame Elizabeth Corley and Ida Levine, amongst others. Do please sign up. And thank you again to DWAT Financial Technologies and FTI Consulting for sponsoring this series of Prime Time. If you're interested in sponsoring a future event, please do get in touch. Thank you also to Lexis for assisting with promotion. And finally, Prime Finance accepts donations through Friends of Prime to support its work. If you'd like to make a donation or to find out more, please contact the Secretariat using the details showing in the chat box. Thank you very much, and goodbye.